everybody, and welcome back to the 50-Day Property Challenge. Once again, we have Matt L. and Jared with us. Today, Maya Deval, our attorney, will speak about property legal aspects. We are going to cover two topics. The one is the offer to purchase, how to go about putting in an offer to purchase, what the requirements are, what the pitfalls are, what you have to look out for, etc., etc. And then we will talk, on top of that, we will also talk about structure. What type of structure you require, legal structure, whether it's a PTY limited in your individual capacity, etc. So I am not going to give a long introduction to Maya because he can do that himself. He'll talk about himself and his company. So Maya, over to you. Tell us about yourself, tell us about your business, and then tell us about an offer to purchase and all the aspects that we need to understand in order to put in a proper offer to purchase.
Good afternoon, Michael. Thank you very much, and thank you for the opportunity to be here. Maybe we must just mute the mics while the others are not speaking, because I think there's a little bit of feedback there. So my journey comes back quite a long time. I started working in the Master of High Court in 1980. Now that's a long time ago. And then through that, I gathered quite a lot of experience on estate matters. And I came to Cape Town about 34 years ago. And then I actually started as a property attorney. And I also started going out and doing lectures on property matters. And I gained most of my big clients being property developers and doing lectures for the late Tony Collins. And he invited me on regular events that I would do special lectures on sectional title, because I'm still a sectional title expert, and opening of sectional title schemes and all complex matters. And through that, also the experience that I gained with the Master of a High Court, I was able to plow that back into the structures of your own personal estate, setting up a company, setting up a trust. And I just had a meeting now about 2 hours ago with a lady that needs a trust. And then we look at the special needs trust. So that's also one opportunity available. So through the years, I've started in lecturing into various property matters. We also developed the concept of rent to buy. We also then kind of spearheaded a huge driving on a national scale on assisting people with a government subsidies called FLISP. You can go to our website, flisp.co.za. And then we also developed software that's used by one of the biggest bond originators to pre-qualify you for a home loan. At the moment, this company sends about 9,500 online clients to our platform every month where they can pre-screen them for buying a property. Now, this all interacts with the concept of you first have to engage to buy a property, and your first document you sign is an offer to purchase or a deed of sale. So I've been involved in this in many years on the academical side, and we also assist a lot of first-time buyers, experienced buyers. We have a lot of clients that buy for millions and millions of rands. For me, the best achievement I find is to help a person that's a first-time buyer that gets access to a subsidy. This morning, I did some research again where I see that one bank approved the home loan of a client of prime plus 1.8%. I did a calculation on how much you would pay if you pay extra on your home loan for 1.8% for 20 years. This bond was for 30 years. I then just worked out if subsidy of 71,000 Rand would be paid into the home loan, what different interest rate the client could have saved. It's almost half of that home loan that a client would save. And the bank don't tell people about this. So recently I had an article out to say, is there a possibility of a class action against banks because they don't help clients to actually tell them all the things they need to know when they apply for a home loan. So we're going to discuss first-time buyers today. We're going to discuss experienced buyers today. But it all comes down to negotiate the best interest rate when you buy the property. And to be able to do that, you've got to put the best foot forward. And to put the best foot forward, you've got to look at what's my credit score, what's my affordability, and do I have access to deposit? Or did the government actually save money for me? It sounds weird, but did the government save money for me in respect of a first-time buyer subsidy called the FLISP deposit? So if you don't know about this, you go ignorant about buying a property, and most likely this ignorance will cost you hundreds of thousands of rands. So Nigel, I again applaud you for sharing, making the platform available that we can share this information with your followers in what you've done over many years. So I'm ready for us, and let's kick off and just start discussing. We're going to discuss deeds of sale today.
Correct, yes. So there are two, like I said, two things we're going to talk about: offers to purchase or deeds of sale. And then we're going to talk about structures and so on. So let's first talk about offers to purchase, deeds of sale, and let's even get into title deeds and understanding what it is, what a title deed is, and what that means to an individual owning property. But let's first talk about the process of an offer to purchase. Talk us through the process, what is needed, what are the requirements, what are the pitfalls, and what are the benefits of an offer to purchase for somebody who wants to buy property.
Well, the first thing we need to understand is when you buy a property, it must be in writing, the agreement that you have. We often find people come out to us with a piece of paper, and it's an affidavit that they sign at a police station to say, I am hereby selling my property to you, and you pay me 150,000 Rand cash, and off the seller goes with the cash money, and the buyer's got a police affidavit, and he reckons that is my agreement. Many, many years down the line, they come to us and they on-sell that property, but they don't have a title deed. So the first point is that it doesn't start right. In terms of the Alienation of Land Act, every agreement that you sign between a seller and purchaser, number one, can't be verbal, it must be in writing. It must disclose certain terms and facts in that document to make sure that it's a binding agreement, that I'm selling my property to you for a certain amount of a monetary value. It may be a cash deposit, it may be a home loan, whatever you finance it, and that must be a legal agreement that can hold up against you even after your death as well, against your executors as well. So it's a legal agreement between the seller and the purchaser. In that, you identify the seller and the purchaser by name, identity number, and how you married. Now, how you married is important because if you are married in community of property, you can't sell that property unless you got the permission or the co-signature of your spouse. Because in terms of Section 15 of the Matrimonial Property Act, both parties have to consent to a sale when it's fixed property. So you identify the seller, you identify the purchaser. In terms of our FICA requirements, you need to also have proof of address of where the person lies. And again, a lot of estate agents leave out the address of the seller or the purchaser because they are much in a rush and they don't care about that. Now, if you leave out the address, the problem lies if one person is in default in the future because they didn't pay a certain amount of money or they didn't do something, then you can't send them a letter of demand and say that you are now in arrears with something or you are in breach of a contract, and then you've got no address to deliver the documents to. So all these components form such an important part of a transaction that you've got to make sure everything is done. All the T's are crossed out and the I's are dotted. So now we identify the seller, we identify the purchaser. If we're dealing on behalf of a company, you've got to have a resolution passed by the directors and the shareholders of the company. If you're dealing with a trust, interesting thing is that trustees can't ratify the sale of or the purchase of an agreement after the fact. The person acting on behalf of a trust must be authorized before you enter into that agreement. Otherwise, that entire agreement can be regarded as not valid. So it's very important when dealing with a property as a seller, as a buyer, as an agent, as an attorney, make sure that you properly identify the parties. Now we know we've got the seller, we've got the buyer, and we've identified them. The next step would be to identify the property. Often I get a deed of sale where they say, I'm selling Earth 2156. And I say, okay, where's this property? Is it Cape Town, Durban, Belleville? Where is it? If you're on George, maybe you'll find your house on a float or a pontoon down towards the sea after all this. I was actually in driving through George yesterday at 6 o'clock. It was horrendous, the water that came down. So depends on, you've got to describe your property. If it's a sectional title property, you'll have a section and also an undivided share in the common property. Now it means that you've got an undivided share in the rest of the property that's outside your section. In a sectional title scheme, you may have exclusive use areas, you may have parking bays, you may have garages, you may have rules that confirm the rights of the use upon a person that owns the property. So you've got to go and identify what is your ownership type? Is it freehold, sectional title? So the seller needs to get all that information together. And if you're an agent, if you're a buyer, the nice thing about this information is available to every South African. If you are buying a property, go and draw a deeds office search. Go and draw a property valuation and go to Lightstone, go to a lot of these companies where you can get a report. You pay a little bit of money for that, but then you get to identify the person. We often had transactions where property was sold and the seller passed away, but the seller is not the owner of the property because they inherited the property from a grandfather, and that transaction then gets complicated. So first thing is to gather information. Identity of the seller and the purchaser, the right property description, and also don't try to describe a property as number 20 Tambuki Lawn or whatever, because that's difficult to identify the earth according to the deeds office information. The same applies with a section number. You may live in flat number 15, but in real life, your section number is section number 220 in the sectional title scheme known as Palm Heights. So identify everything properly. Now you've identified the seller, you've identified the purchaser and the property. Now you've got to describe how will you pay for this property. You first got to determine your price. So I'm buying the property for R1 million. Now the trigger bells goes off for the buyer. If I buy under R1 million, the transaction is exempt up to R1 million for transfer duty. You've also got to ask a question, am I paying this purchase price and is it from a private individual? And is that private individual registered for VAT, or is it a company or a trust or even a CC that are still in existence? And do I have to pay VAT on top of the purchase price? So that the general rule is that if a transaction is silent on that, then the purchase price includes VAT. But the seller can be a non-VAT vendor, and then the purchaser, if the price is over R1 million, you've got to pay transfer duty on top of the purchase price. So as a purchaser, go and do your calculations. This R1 million or R2 million that you're going to pay, how much will it cost me at the end of the day? Now you've identified and you've agreed on the purchase price, and it's almost like you've shaken hands, but now you've got to bring that into the deed of sale or the sale agreement. And just maybe go back to that. A lot of people I've recently had where they say, yes, I did sign an offer to purchase, but you know what? Now I want to keep me responsible for that. And I say, no, what don't you understand? They say, I only made an offer to the seller. And the problem lies that people don't understand that you signed an O2P, an offer to purchase. And once the seller accepts that O2P, it doesn't mean that you're going to have to draw a new deed of sale. That offer to purchase contains all the requirement elements of a legal and binding sale agreement. And once the offer is accepted, it becomes a legal valid agreement. Then you've got to perform in terms of that offer to purchase. You've got to put down your deposit. You've got to apply for a home loan. And if you don't do that, you may be in breach of your agreement. So it's critical that you actually understand what you've got to do and take from it. Sorry, there's a line that you just switches off. So it's critical from that point that you understand what are your legal terms and conditions and what you've got to do in terms of your obligations. So now you explain in the purchase agreement, how will you fund this property? And you say, I'm going to buy it for R1 million. I've got a 10% deposit, and the rest of the 90% I will go to the bank to apply for a home loan. Now, if you're a first-time buyer and you earn up to 22,000 Rand, you can get a fantastic subsidy from the government as a first-time buyer. To get a subsidy, you must have a home loan approved, or you can apply after the deed of sale was signed. You must be a first-time buyer, never owned a property before, or your spouse. You must have a financial dependent, such being a child or a spouse, and your income must be between 3,501 Rand and up to 22. Now, for example, if you earn 15,000 Rand, your subsidy will be roughly 63,000 Rand. Now, if you apply for a home loan of 650,000 Rand and you put down a 63,000 Rand deposit, what do you have? Immediately a 10% deposit. What does it mean for you as a buyer? The banks will love you. The bank will say, hey, Maya, come here to me. I want to give you the base interest rate. I want to actually reduce your home loan rate, not to 30%, but over 20%, 20 years, because you are such a fantastic client. I'm going to treat you as a VIP. Compare that to the client that goes to the bank for 100% loan. I just had it this morning, where they got prime plus 1.8. They stretch their home loan repayment from 20 years to 30 years just to try to fit in the repayment. So it means that the client is paying back his home loan over 30 years. It's a long, long term. If you calculate your money that you pay over 30 years compared to 20 years, it's a month, it makes a small difference. But over 30 years, it's a high amount that you pay. So again, if you structure your property purchase, if you have saved for a deposit, or you have got a fixed deposit, you say, I'm buying for a, let's call it 900,000 Rand. I've got a fixed deposit. I'm using a home loan for the balance. Maybe I've got my own deposit. So that is how you negotiate and put in that this transaction is subject to property finance. Now we call that a suspensive condition. Suspensive means that it is pending until something happens. So it is subject to the condition that I get a home loan approval. Now, if you have, the bank comes back to you and say, you applied for you bought a R1 million property, you've got a 200,000 Rand deposit, you only need an 800,000 Rand home loan, and the bank comes back to you and say, I'm only going to give you 750. It means that you can actually walk away from that offer to purchase, because the protection that you've built in for yourself, getting a home loan of 800,000 Rand, you didn't meet it. So there's no obligation. And if you did pay a deposit, they're going to pay your deposit back to you. You obviously have to do everything you can to get this home loan approved. You can't just sit back and let time fly and say, sorry, but my home loan was not approved. Then again, you are in breach of your contract. But let's say the bank comes back and only offers you a 700 or 750 bond. What does it mean? Do you still want the deal? So you can actually waive that protection that you had for the 800,000 Rand bond, and you say, I only want to take up a bond of 750. I'll contribute the rest and the shortfall in cash. So that's a waiver of your protection that you have in respect of your property finance. My recommendation would be to look at maybe about a 21-day period to get your property finances sorted out. It depends now if you are buying in your own name, which is quite easy. If you are self-employed, it becomes a little more difficult. If you work for a salary, then you can submit your payslip and your credit score, if that is strong, most likely you'll get a home loan quite easier than a self-employed person. So if you buy on a trust or a company, give yourself a little bit more time. Same with self-employed, to get all the paperwork done, because the banks then have to process your application manually rather than it goes through a big call center, because there are different rules for self-employed, trusts, and companies. So now you've got your home loan. You say, within 21 days, I want my home loan to be approved. And quite often they work in an extension period there, that if your home loan doesn't come through in 21 days, then they give you an extra maybe 10 or 14 days. Be careful now for this time, because now obviously if you're a buyer, you want to build up in for you the best possible extension and time frame. Now, if I'm a seller, I would say, hang on, I'm being put out of the market here for a period of 21 days or a month. What happens if another buyer comes to me and he says to me, I'm putting up a cash offer? So a estate agent would most likely work in what they call a meet and beat clause, or a 72-hour clause. 72-hour clause and a meet and beat quite often comes in when you are you have to sell another property before you actually can buy this property. So they will say to you, it's a little bit unfair to keep the seller out of the market, because you've made an offer subject to a bond, you've made it subject to selling your own property, and I would like to work in and add to the contract a 72-hour meet and beat clause. It means that if a cash buyer or a buyer with a better offer comes around, I will have to present that offer to you and say, Nigel or Maya, I've got a better offer here. Can you meet or beat this clause? If you can't do it, then you've got to walk away, and then the second buyer will be able to buy. So remember, this is a clause. If you're selling, you would like to negotiate for yourself the best of two worlds or three worlds. If you're buying, you want to do the best of one world, because you want to secure the deal for yourself. So it depends on how you are looking at the transaction and how you are structuring it. Now the next thing comes where agents make, and it really freaks me out, where they put in the occupation clause. Now occupation, there are two different aspects about from taking occupation and possession. One is possession, and that means I possess something, and that is normally on date of transfer. In possession, you take over all the risks and responsibilities. Now, talking about George earlier, we made a joke of that. Just now, somebody phoned me where a liquidator basically took over the portfolio of an insolvent person. He didn't extend the insurance on the property. And yesterday, what happened in George? The entire house flooded. New carpets, damage to the walls, all the parkway floors are damaged beyond. And what happened? The seller, the buyer can't take responsibility for that, although they have moved into the apartment and they're renting it already. So the problem lies that if you have not taken possession, the possession lies with the seller, and all damages up to the date of transfer then is a requirement of the seller to repair and to fix. Now, the different one is the occupation date. So the occupation date is to say, I want to move in earlier. I want to take occupation earlier of this property, and therefore you've got to pay occupational rental for that property. So it's important then that you negotiate, and as a purchaser, I would be very careful not to take possession as well, because with possession it becomes all your responsibilities. So you want to take only occupation, rent the property for a period of time, and pay occupational rental. It's up to you to negotiate to say, I want to pay levies and rates and taxes and insurance as well. Normally, if you rent, you don't pay that. Now, the biggest thing where I find a huge gripe with a lot of estate agents, they say there's a clause to say there's about 3 different alternatives. I'll take occupation subject to existing leases. Now, if you buy a property and you want to live in there, you don't want to buy the property with tenants, because there may be a lease agreement that runs for the next year or 6 months. You're paying a bond, and that person pays you a rental, and that doesn't cover your bond repayment, and you bought the property to live in. So number one, it's critical to look at, to say, I want to have vacant occupation. It's a thing that they always leave out. They just leave it open. The other day I had agents saying to me, no, but what if the seller wants to maybe rent it out? I said, you've got to ask the seller, the buyer, I want to live in that property, and I don't want to have a tenant living in my place that doesn't pay the rent, or does pay the rent, but I then have to pay rental to another place. So occupation is a critical component. Quite often they say occupation will be on date of transfer. Now that's also good, because sometimes people don't want to have people moving in before date of transfer, because then they start finding faults, and there's a skewed thing this, and there's a problem there. So a lot of sellers want to say, I don't want you to move into the property, because otherwise it's going to be a nightmare of complaints about this and this and that. So because I sold the property, and this comes to the next part, I sold to you as is. I sold to you footstewards. Now this footstewards is a word that comes from many, many, many years back from the Roman Dutch law, but it's still very applicable if you buy a property from an individual private seller. It's not so much. You get a lot more protection when you buy a property from a property developer, because they can't hide, if we call it like that, behind the footstewards clause. Now, in the footstewards clause, you've got 2 types of defects that are relevant. One is a latent defect, and the other one is a patent defect. And I always try to remember now, how do I remember latent and patent? Because effectively, what you see is what you buy. Now, if there was something hidden, maybe there was a carpet over a hole in the floor, or they did maybe hang a painting, or they repainted the property over a crack. Now, latent means, and I always remember it, the L stands for lie. So it means that somebody lied to you about the property and didn't disclose to you, and they were almost like hiding it from you. Then you can't, the footstewards clause won't protect the seller, because that is called a patent defect. You walk through a place, you looked it around, you say, I'm kind of happy with that. But as we all know, that we only don't buy properties every day. So we're not experts. So a lot of people think that they switch on the lights, they flush the toilet, and they run the cold and hot water, and they feel that is their due diligence. And that's the worst thing you can do, because if you buy a car, you go and get a roadworthy certificate. If you belong to the AA, you get a certificate from them. So you sometimes even get a guarantee on a second-hand car. You don't get a guarantee. You don't get a warranty on a house. You do get a beetle inspection and a plumbing certificate, but that's not a guarantee or warranty. So it's so critical to make sure that, how do I protect myself as a buyer? And there comes in a special clause that you can say, You don't want to go out for every property and do a property inspection report and get an outside company to do that for you, because it costs you 3, 4, 5, 6,000 rand every time you view a property. You would rather say, I'm submitting this offer subject to 2 suspensive clauses. The one suspensive clause is that I will get a home loan. And if it doesn't get a home loan, we've already dealt with that. The second one is that I have an opportunity within a 5 or a 7-day period, suspensive clause, that I can bring at my own cost a property valuation, not a property valuation, a house inspection expert. And this person will scrutinize for me everything in the property. And if I'm not satisfied with that condition that they've created, then I can actually walk away from this deal. So there you build, particularly if you buy cash, I would never buy it without a property inspection report, because there's no bank behind you that can look at your valuation. And even the banks do a desktop valuation, which means that they really don't inspect the property for all kinds of damages and structural problems. So don't rely on the bank to be your protection. So you've got to do your own protection. And even if there are no building plans, the bank, don't worry about that if they give you a home loan. I'm busy with a situation right now, where the purchasers signed an offer to purchase for a property that was halfway constructed. And in the deed of sale, they say, you are buying this foot stewards. Now the seller wants to rely on the foot steward clause. And I said to them, hang on. Foot stewards is that you buy what you see. Now, the time when we saw it, it was only on foundation level, maybe 5 bricks up. You can't try to sell somebody foot stewards that is now newly constructed. We've got to work in their snag list. We've got to work in guarantees. And on top of this, the seller in this transaction didn't register with the National Housing NHBRC. So now that property doesn't even have protection under the NHBRC, which is a period of 5 years and a little bit of reduced for certain type of guarantees. So again, if you buy a property, rather get an expert in that help you with this. If a property is younger than 5 years, make sure that you get an NHBRC certificate. Make sure that you get an occupation certificate, because maybe they just built their house and people moved in, and really that property is not habitable yet in terms of requirements of municipality. So if it's a new building, ask for all these certificates. But definitely, in my view, insist on a property inspection report that you can pick up afterwards, that after you sign the deed of sale, but before you finally agree on accepting that all the suspensive conditions are met, you then make sure that you've got a professional going through everything. And quite often we find that people come back, they buy the house in summertime. Now in Cape Town, it's also it rains, seems to me, a lot in summer now. But you buy a house in the Western Cape in let's say in February, where we don't have a lot of rain, but come winter, it starts to leak like a sieve. And now you say, the seller says, but I never had problems. And then you get into the roof and there are like 7 buckets standing around there. Then you know it was a latent defect. They didn't disclose to you, and they can't hide behind that and say, sorry, but I didn't know about that. Often we find where people are renting out properties when they don't know so much about a little bit of a problem here and a problem there. So make sure that you get a professional in, because buying a property is the biggest investment you will ever make. And you don't go around and do that without professional assistance and help, because once you've bought the property, you are the owner of that property until you sell it one day. And if you don't have building plans, you don't have an NHBRC, you don't have occupation certificate, you have to sell it now to the next person that is wide awake. And he's going to say to you, no, 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 I'm not going to buy this property with all these defects in. You've got to reduce your price of 100,000 Rand. And now you're picking up the bad quality of the seller, and it flows over to you. So now we've dealt with the identity, the property, the price, the finances, and we looked at occupation and possession. And if you do buy a property as an investment, what's the first thing you'll do? You'll get a copy of the lease agreement of your tenant, the new tenant. You'll also get a record of payment of this tenant. Now, the nice thing about that, there's also a platform called TPN, Tenant Profile Network, where you can actually draw a report from this tenant, because you don't want to buy a property with a client where they have been defaulting all the time. All of a sudden, you bought a property, you've got a bond over a property, and now you're sitting with a tenant that doesn't pay the rent. you've bought a bad investment there. And you want to make sure also that you get all the reports on tenant behavior, that when you take over a tenant, how long does that lease run? You don't want to sign up for a lease that it doesn't give you a good return on your investment, but you tie it for the next 3 or 4 or 5 years. So make sure that, particularly when you buy a property, I always say that buying investment property is one of the best investments you can ever make, because it comes down to the concept of gearing. If you have R1 million, you can buy a property of R1 million. If you have R1 million deposit, if you have R1 million property, you can buy shares and stocks and maybe a car of R1 million. But and the car will go down in value, so that's not really investment. But you can buy shares, you can buy stocks of R1 million. If you have R1 million, you can buy a property of 10 times that value, because you can use your R1 million as gearing to go to the bank, and often idle use it OTP, other people's OPM, other people's money. You use other people's money, which is the bank, because you've put down a 10% deposit, and now all of a sudden your R1 million that you have, or 100,000 rand, let's use a smaller amount. You've got 100,000 rand, you put down that as a deposit, you buy a property of R1 million, and all of a sudden you've got R1 million of value that escalates every month, rather than just 100,000 rand that grows according to whatever share price index that you have. So property is one of the best tools to use gearing, where you can maximize the deposit that you have, and then you look at the return on your investment. Now you look at your tenant, how much your tenant will pay you. And I've often said that every now and then, when one of the tenants that I have pays off my property, I take him a bottle of champagne and say, hello, thank you very much. And he says, what? Why I'm getting a bottle of champagne? I say, no, just like you're a nice tenant. I don't tell him that now he has paid off my bond for the last so many years. So I've written some articles and say, stop making your landlord rich. Because obviously every month that you pay your landlord, you make him richer. But I don't tell that to my tenant. We just keep saying, thank you very much for being such a nice tenant. So now we've gone through the occupation clauses, we've gone through the finance, and obviously we looked at the property inspection, we looked at the 72-hour clause, and then there are some conditions that come in. You've got to obviously make sure that what happens if any of the seller or the buyer goes into breach. And you've got to say that there's a 7-day or a 14-day period that you've got to notify the other person that they are in breach now. And if you are in breach and we send you a letter, I give you that 10 or 14 days to remedy your breach. And if you don't remedy your breach by repairing what you've broken, didn't pay the deposit, you didn't pay the transfer fees, and then I can terminate the agreement. So that's very critical to have all these conditions in. And now you get also to your compliance certificates. You get to a Beetle and electrical if you're on the Western Cape, and KZN. If you're on the Cape Peninsula, you have to supply a plumbing certificate that your plumbing complies with the regulations. Then you also have gas compliance, electrical compliance. You also have biodiversity issues that you can address. All these are conditions, but it's not like seen as ultimate protection. So don't see that you replace these compliance certificates with a property inspection report, because it's so critical that you make sure that your property complies with all the other matters that are outside these compliance certificates. And then one thing that I didn't add earlier is obviously also the date of transfer. I actually started on that and then I lost track of my own discussion. If you say, I will take transfer and I will take occupation on the date of transfer, it's a little bit of bad planning, because the deeds office quite often is quite behind times. At the moment, we find the city of Cape Town, the municipalities are behind. So now you want to move in the 1st of February or the 1st of December, but you say, I'm happy to hang on there until the transfer goes through. My recommendation is rather to fix a date and say, I want to move in the 1st of December. I will take occupation then, and I'll pay you occupation interest. At least you can schedule your move from moving out of your one property, terminating a lease agreement or the lease expires, than having to wait for the attorney phones you on the 16th of a month and say, congratulations, your transfer is going through tomorrow. Now you're still stuck with a lease on the one side. You haven't made arrangements with your removal company. Maybe the deeds get rejected in the deeds office, and then got to relodge again. Now you've got to pack up all your stuff in boxes again, or dig it out of the boxes because you thought you're going to move into the house tomorrow. So take a practical look at that and say, I'd rather make it on the 1st of the month or the 15th, but it's more practical on the 1st of the month because lease agreements normally expire at the end of a month and start new on the 1st. So kind of look at the practical side, unless you're living with somebody where you can just say, hey, mum and pop, I'm moving out of a house. I've got my own transfer that will go through on the 11th of the month. So look at your personal circumstances in that regard. Now, if you're buying a property that is VAT registered, normally you would bring in a VAT clause in here to say that I'm buying the property and I'm paying VAT on top of that. You can then add the extra clause to say if it's a going concern, that you're buying the property as a going concern, as regarded as a zero VAT transaction. I'm not going too much into that because I think we're more focused on residential property today. And so those are the terms, and then you can have some general agreements that clauses in the agreement as well, but word definitions and all that stuff. But that very much sums up a purchase agreement or an offer to purchase or a sale agreement. So these are the structures that we have. Then we've got some hybrids that stand next to that, where we get an installment sale agreement. This is regulated by the Alienation of Land Act, but again, that's got a lot of terms and conditions and administration that to work through the Alienation of Land Act. But again, you use the deed of sale as a basic base. We've also developed over a period of time since 2007 the concept of rent to buy, and through the rent to buy, we also again default back to a normal deed of sale agreement or the offer to purchase that we put in. We also have an option agreement. We have a lease agreement that we attach to that. But if you have your basics correct and ready and work on that same term, almost like a template for your deal of sale, you follow those steps and the one follows on the one. Once you negotiated the purchase price, what will the occupation date be? How much will I pay? How much will I finance it? So that's really much in a nutshell the basic principles of a deed of sale, also called an offer to purchase. So maybe from Jared and Beleng, we've got some questions here. Are you a first-time buyer? Are you a seasoned buyer? Because those are all concepts that come out differently, which we're going to discuss in the second phase now. Do I buy on my own name? Do I use a company or a trust? And what do I do, particularly in risk and ownership? And we're also looking at property finance. How easy is it to get property finance on a structure like a company, like a trust? What do I do if I have a new trust or a new company that's set up? It doesn't have any cash flow. I haven't been trading on it. How do I actually buy a property on an entity like this? You've got Miguel as well later on that will come and discuss with you the concept of how access and finance properties where you've got your third or fourth property. So those are all aspects. But maybe let's entertain a few questions now, because I see they've all been patiently waiting for listening, hopefully, here to what we said. So from your side, Mr. Beleng and Jared, you've got any questions from your side?
I don't have any questions. I've just been listening and absorbing what you're saying. Makes a lot of sense, especially around, as you mentioned, with purchasing property, just to make sure that you know what you're buying. Interesting things about Western Cape that I didn't know with regard to property. So definitely lots to think about. Maybe Mr. Beleng has a question. I don't know.
The only question I had was something I think you touched on a while back when it comes to OTP. If you were going, I think you said something like if you were going to buy on a company, there's certain documents you need. I don't know if you called it the resolution or something like that. What exactly is that?
Okay, very good question. So often we find that you want to buy a property not in your own name. You want to buy it in a company or a trust. Now, the one thing is that if your trust is not yet set up and registered with the Master of the High Court, and you don't have your letters of authority, you cannot buy the property, let's say Netabaleng, on behalf of a trust to be formed. You can, however, buy it on behalf of a company to be formed. And then you've got to put in a time frame for you to say, I'm buying on behalf of a company to be formed, and this must happen within 14, 21 days, 31 days, because I need time to set up my company. You can, if you don't set up a company, or the company doesn't take up that offer to continue and replace you as a purchaser, then you will stand in your personal capacity as a purchaser. So that's always a clause that we work in extra into the deed of sale to say on behalf of a company to be formed, but if a company doesn't take up, you'll be responsible person for that. Now, a company and a trust and a closed corporation and any entity works on the basis that they have a representative. Let's say Nigel is the director of a company and there are 5 shareholders and other directors. So we'll appoint Nigel to go and make the offer to purchase, negotiate the transaction. And that's why before you sign the offer to purchase and negotiate, you prepare a resolution, which is like a power of attorney, to appoint Nigel or Jared or yourself to act on behalf of the company to, number 1, identify the property, to negotiate the purchase price, and then sign the offer to purchase or the deed of sale, and then also sign all the transfer documents, and then later on also the bond documents when it gets to that point. So in a company, you always must have a representative, and it's required to have a formal legal document, which is the resolution, similar for a trust, similar for a company, that authorizes a executive person on behalf of that to sign and negotiate the documents. So interesting, as I said, the nomination. I'm just going to add one more clause there. In respect of a nomination agreement, if you don't nominate and there's a purchase transaction where the seller is not registered for that, you have to nominate on the same date when you have to nominate your company on the same date as when you signed the offer to purchase. When it is, or a deed of sale, when it is a VAT registration, you don't have to worry about the 24-hour or the same date clause. If you don't do that, SARS can see that nomination of your buyer. They can see it as a double transfer transaction, and they can hit you twice with transfer duty. You've raised your hands there. You've got a question?
Yes, I have another question. So I don't understand this concept of buying a property on a company that's still to be registered. So what do they base the, how can I say, the credit on if the company is still to be registered? I want to understand that.
Are you referring to property finance or just the concept of the legal document?
The property finance.
Okay, that's a good. Shall we deal with that in the second part, Nigel, or shall we? Let's address it now, because otherwise
we can address that now because it's pertinent, and we can just reference it again later when we talk about structures.
Okay, so if you have a new company or a new trust and you decide this is going to be my vehicle to buy the property, you've prepared the resolutions and you call it ABC Pty Limited, and it goes out and it secures a property to buy. Now, the next thing is you're going to go to the bank and say, ABC needs to raise a bond with a bank for R1 million. And the bank will look at this and say, hang on, this is a new company. It doesn't have any financials, doesn't have any records. And similar as a trust, the bank will look behind the trust or the company, who's standing behind that. And they will look at the directors of a company and quite often also the shareholders of a company. And same with a trust. They look at the trustees that are also beneficiaries in the trust to say, I would like to have your personal finance support behind this to make this transaction work, because you'll say, hang on, this company is going to buy a property as investment, is going to rent it out every month for 8,000 Rand, and I'm going to give you the rental income to pay the bond. As the bank says, no. What happens if this rental property stands empty? And then they require you as the director of a company or the shareholder of a company to provide a personal suretyship, because you'll have to chip in that money every month into the bank account on the bond account if there is no income coming forward. So you can use the rental income, but they won't allow the entire income of your rental agreement. Now, this is where the nice thing where ABSA comes in, as Miguel will explain later. The bank, ABSA Bank, does recognize income from lease agreements for a certain value as a part of your income that will, if you start investing in property, particularly when you get to your third property. But as a new entity, definitely the entire application will stand or fall on your personal suretyship, your personal income, your personal credit score. Because a trust doesn't, or a company doesn't even have a credit score, it hasn't opened an account. You just formed the company 2 weeks ago, and therefore you are going to look at the jockey behind the legal entity and use that information for the property finance. So this is where you'll have to stand in surety for this, and also be therefore important that you check out your own credit score, have your own financial documents available by the time when you apply for the home loan on behalf of the company.
Right, that was quite a significant amount of data and information that you have given us, Maya. So I think at this point in time, we're actually going to end this session, and we will start a second session so that the public that are watching us don't get overwhelmed by the amount of information and data that is being brought forward by this particular session. Offers to purchase are complicated at times, and there is a lot that we need to make sure that we look at and ensure that we bring into the offer to purchase. So guys, thank you very much for this time. Thank you, Ntabaleng, better known as Matt L. Thank you, Jared and Maya, for this session. We will do another session later today where we will talk about the legal structure and how you should structure your business, whether you are buying one property or if you want to build a portfolio. So thank you, everybody, and we'll see you again later today.